No, do not collect $200.
Hey folks, Reno News Now here, also known as the ADHD Auditor, coming to you with another video. We got a lot of content today, folks. We're going to be covering Sacramento Community Watch's Chief England to what happened with Chille DeCastro and kind of go over the court filings on everything that happened recently inside Sacramento Community Watch's Chief England's case. Maliciously prosecuting Chief England. So we're going to go over that today. So in case you haven't figured out what's going on, or in case you haven't followed along, go take a look at the playlist for Justice for Sacramento Community Watch. We do have a few live streams where we covered over the court audio, and I'm kind of doing this a little bit solo today, folks. So thank you for tuning in. If you're joining us live, it doesn't look like there's very many people live in here yet. I hope there will be. Also, if you're watching this afterwards, please hit the like, share, and subscribe buttons, folks. Every little bit matters. I'm trying to get my content up. Work has been really busy. I know I'm just going to go into a little bit of housekeeping here. I know in my last videos, I was promising that I was going to give you some content from Blackhawk, Colorado. Work sent me out there. When I got out there and was actually had planned to do my First Amendment auditing, my boss wanted to go out and tour the area because this was the first time that we were in Blackhawk and got to visit the property. So unfortunately, I wasn't able to bring you any content from Blackhawk. It was just so busy, and work has just been so busy. It's hard for me to get content to you. As you know, I am a member of Sacramento Community Watch. I am also the name escapes me, watch commander. I'm the watch commander for Sacramento Community Watch, and my job is to basically make sure that we keep our people informed and what to do and how to handle these things, and to bring internal content to our members who are actually out there in the field helping us. So with work and everything being busy, I was able to do some FOIA requests on Chief England's court case, and we got some of that stuff. So in case you don't know what happened, I want to go ahead and play Chief England's video. Now, what wound up happening, and just context for you, he wasn't planning on auditing that day. He just came right out, seen cop car across the street, seen what was going on, and pulled out his camera. Now, in the video, you're going to see him saying, get out of the street, you know, and he wasn't in the street. He was behind a parked car. And it's just downright silly what this law officer, or this Tony the Tyrant, has done with Chief England. It's just, you know, and we're going to do everything to make him.
Am I going to be famous too? You're going to put me on your YouTube video?
Yeah, we're going to put you on a YouTube video. So here's, I want to go ahead and play Chief England's video from that day and let you see what was happening. Again, there's no, in his video, there is only a stolen car victim. There is no criminal. So what happened was the stolen car victim flagged down Tony the Tyrant and said that she found their stolen car. So I'm just going to go ahead and play that video for you now so we can get caught up on that. And then I'm going to play Chille's video and we can tell the difference here.
Ladies and gentlemen, welcome to Sacramento Community Watch. Look like we have Officer Sotello here, Reno PD.
And why do I not have audio? I apologize, folks. Let me see if I got video on another video here.
You good? Why'd they say that you were pulled over?
That one works. Let me just remove the other one from the stage and add it back in here. I do apologize, folks. Things led me astray here. Let me find that file one more time. I had it all queued up, and it just went poof on me. Oh, let's see. My asset. Where's my... Oh, there we go. It's at the top of the list. Streams. Okay.
Welcome to Sacramento Community Watch. Look like we have Officer Sotello here, Reno PD. It's going to be vehicle 192. It's going to be Officer Sotello. We've had run-ins with him before. He has a really bad attitude, really bad.
Very bad attitude.
I'm not in the street. Not in the street. You good? No, I'm good. There he goes, giving unlawful directives, telling me to get out the street.
And I'd like to point out, folks, Tony the Tyrant doesn't know what a lawful order is. Most RPD officers don't know what an lawful order is. Go back and watch our court coverage live streams. It goes about 3 videos. The third video is where I believe we cover Tony the Tyrant. The second or third video. No, it was the first video. The first video is where we covered Tony the Tyrant. And the prosecutor, Miss Schumann, even objected when he asked, when the defense asked him whether or not he knew what asked him what a lawful order was. And she objected. You know, cops giving out lawful orders every day, day in and day out, and they don't know what a lawful order is. Usually they think it's anything that comes out of their mouth, folks, and it's not.
So what we're going to do is we're going to go down here. We're going to cross the crosswalk so we can get a better view of them. It's going to be vehicle 192, as stated before. Occupy one time. So let's go ahead and cross the street. See what he says then.
And I guarantee you, Tony the Tyrant would have arrested him.
Get on the street, you're going to get hit.
Chief England did everything legal in this. Everything legal.
Now we have all free range on a public sidewalk to be able to record, see what's going on. 210392 is that unique ID number for this officer. How's it going, Officer Sotello? Stay over where? I'm on a public sidewalk, dude. There's no tape up. You don't know.
So I'm trying to investigate. Okay.
And folks, if you watch the body-worn camera side of things, which again is in our live streams, you knew he was not investigating a stolen car. He was sitting there slack-jawing with the stolen car victim. And it appears that if the stolen car victim had any threat of fear, she would have been behind the officer. She wasn't afraid.
We understand. We understand investigations.
Go over there.
What's wrong with right here?
Because I can't have somebody behind my back while I'm trying to investigate.
Oh, I'm good.
You're not going to be detained, okay?
Why would I be detained?
Because you're being detained.
Okay.
My investigation. Okay?
Okay.
So, folks, I'd like to point out Interfering with an investigation in Nevada is a physical act. Resisting a public officer, which is what we call in the First Amendment auditing community contempt of cop, has no restriction like that. It's basically refusing anything that the officer says, willfully disobeying. We've gone over it many times before. The law, in my opinion, is unconstitutional on its face. We have no resisting arrest laws here in Nevada. And to be quite honest, this could easily be turned into a resisting arrest law if they would properly rewrite it, but it's not properly written at all, and it's constitutionally vague. The fact that it hasn't been overturned by the Supreme Court in Nevada or by federal courts is astonishing, because almost every single time that it has been used or somebody has challenged it, there's always been interference. And there was no interference in this particular scenario. There was no willful delaying or obstructing the officer. So again, we're going to kind of compare and contrast this with Chille DeCastro's arrest for the same thing. Now, in this video, I'd like to point out that with Chille's case, there was a not a victim. There was a suspect. Okay, in a traffic in an auto stop. So Chille got in the middle of that a little bit, but again, he wasn't in the middle at all. So let's go ahead and watch this, and then we're going to compare the court cases just a little bit after we get done.
Oh, I see.
Like, what a
Oh, I see. Oh, gotcha.
Okay, folks, so you heard her right there. She says, it's my fault. She knew she did wrong. She basically admitted it. You never admit that. You always keep the right to remain silent. I don't answer questions. Here's my information. You ask the questions. Don't ever answer the questions for the cop. Do you know why I pulled you over? Officer, why did you pull me over? Do you know why I'm stopping you today? No, officer. I'm not a mind reader. Why did you stop me today? Do you know how fast you were going? No, officer. How fast was I going? You know, basically they're trying to get you to admit fault, and she basically did. So let's keep going here.
You need to stay away from my driver. Back up. Back up, or I'm going to detain you.
You're going to detain me how? In which way?
Get away from my car.
Actually, I'm standing right here. I'm at least 10 feet away, officer. I got to tell you, I'm a constitutional law scholar. You can do whatever you want, but just understand something. Your name will go on the lawsuit. Mind your own business. Mind your own business. I'm a member of the press. Go get in your car and do your job, little doggy. Go feed her.
You're being detained right now.
Okay, then detain me. Oh, she's free. Oh, you're going to detain a journalist?
Yes.
2015, Rodriguez.
Come over my car.
Don't put your hands on me.
Come over.
Don't touch me. Don't put your fucking hands on me.
I'm going to put my hands on
No, you're not. I gotta make sure. Hey guys, make sure you guys get my people on the phone. Oh, this is so you ended the stop, you dunce cap. Did you just end the stop? So that's
Yes.
a 2015.
Over here in my car.
No.
Okay, so I'd like to point out, folks, that he ended the stop. So whatever he got her on and she admitted to fault for, he just let her go. The stop's ending. He can no longer interfere or obstruct. He wasn't interfering or obstructing in the first place. Obstruction is a physical act. Us going up there and being within 10 feet of the camera is not of the officer with a camera is not obstruction. It's officer cowardice whenever you follow the officer safety. Public safety comes first. You're a public servant, officer. Learn the law.
Over here.
No.
Need an additional unit.
Bring your supervisor, please. Bring your supervisor, please. Don't touch
Over
me.
to the car.
You don't get to put your hands on me. Don't grab me. Don't grab me. Listen, you're not. First get your supervisor out here. You're not just going to grab me and throw me on the ground. You've already released her. You've already released her. This is 2015 Rodriguez versus United States. I'll walk right in front of your car. Let's go. Sure, come on. Come on. Come on.
You need to set the phone
There you
down.
go.
On
No,
the hood.
no. I'm a constitutional law scholar. You can't take away my
Set the phone down on the hood.
I'm now in
You're being detained. Now you're going to put hands on me.
No.
Come over here.
Why are you grabbing me?
Come over here.
Sure.
Come over here.
You see what that officer did? He did everything he could to get that phone and that camera out of Chille's hands. everything he could to make him stop recording what he was doing. They're afraid of the camera, folks. It's the one thing that keeps them accountable.
I don't care about the phone.
Why are you grabbing
Turn
me?
around.
I'm a
Turn
member
around.
of the press.
Turn around.
I'm not doing anything.
You're being detained.
I'm not
now.
doing
Turn
anything.
around.
Get your
Officer, why I don't care about the camera.
Are your cameras on? Are your cameras on?
Yeah, it's on.
Okay, then
Put
don't
your hands
put me
behind
in-
your back.
No.
You're going in handcuffs.
Why?
Put your hands
Why?
behind your back.
Can we slow down? Get a supervisor. I haven't done anything
No,
wrong.
put your hands
I
behind your
haven't
back.
done anything wrong.
Don't make me
If you want to
Hasn't done
detain me,
anything wrong.
I am putting you
He
in
even took a couple
handcuffs.
steps
I'm not
back.
putting my
You're
back.
He proved
facing
it
the
in court.
hood.
I'm
Turn
facing
around.
the
Not
hood.
within policy to put it behind. It
Don't
has
put
to be
it-
behind your back. Right now, you're going to get a ticket.
For what?
If you do not put your hands behind your back, you're going to jail. Put your hands behind your back. Do it now. No. No, I don't
Resisting
know
a
if you have
public
any weapons.
I'm a journalist. I'm a constitutional law
This
scholar.
ain't resisting arrest, folks. This is contempt of
Put
court.
your hands behind your back. Turn around.
For officer
Turn around for officer safety.
Is the camera still running, guys?
For officer
The
safety.
camera's still running.
I
I'm
don't
seeing
care.
your car.
I
Like,
don't-
That's a big buzzword. Officer safety. Officer safety. Officer safety. Big buzzword. And there's no law for officer safety. There's case law for officer safety. And the way case law, the way I understand, because again, I'm not a lawyer. I don't assume to be a lawyer, and any legal advice I give in here should be automatically dismissed because I am not a lawyer. However, we can read the laws, we can understand them, and we can figure it out. I play one on YouTube. I don't play one in real life. Come on, folks. This is the court of public opinion, and this is what we're doing. We are going through the law.
I don't care.
do.
I don't
I'm
care
facing
about
your
the
car.
camera. Put your hand behind your back. Do not reach for this phone.
Thank you.
Put your hand behind your back.
Okay, there you go, dude.
Do not reach for this phone.
There you go. Please don't.
Officer safety.
There's no reason I'm not gonna-
What kind of officer is afraid of a cell phone? Do not reach for that phone, officer safety.
It says to run. Get a supervisor here, please. Okay, for those items, put 'em on.
That should be a law too, where if somebody asks for a supervisor from the police and they go, oh, well, we don't have a supervisor, or there's no supervisor available, or I don't have to get one, or any of that other BS, the moment you ask for a supervisor, everything should stop unless it's a felony detainment. Everything. I like Chille's approach whenever he says it's like virtual detainment. You are detained. If you leave this spot, you're going to be arrested for fleeing the scene of the crime. You know, you don't have to detain everybody in cuffs just because they're being detained. It's so stupid. Again, appropriate use of force.
There's no reason. I'm not going to try to fight you. You grab me for no reason. I can't. My shoulder's got a tip on it. I can't. You're going to hurt me. My left shoulder. Please don't hurt me. There's no reason to hurt me. Hey, you guys film this, please. Pull out your camera. There's no reason to do this to me. You're just exerting power. Please get your supervisor. You're going to face a lawsuit there.
Go ahead, sue me. That's fine. You're obstructing.
Go ahead, sue me. You're obstructing.
What did I do? You ended a stop, you dunce. You can't end a stop. It's Rodriguez versus United States, 2015. You can't.
No, I have a different stop now. My stop's now with you.
No, you
Separate
extend.
your feet as far as you can.
Go ahead.
Tag you for weapons.
There's no weapons on me. Go ahead, put your crop fingers in my butthole, bro, if that's what you want to do.
Separate your feet as far as you can.
This is as far as I can go, dude. There's nothing on me. I don't have any weapons.
Separate your feet further.
No. You
Separate
can
them
feel
further.
the camera's rolling, bro. I'm detained, officer. Please, the camera on me. Okay, I'm detained. So I'm not.
No, he's under arrest.
I'm under arrest.
Going to jail now.
I'm going to.
And they shut off the camera. Yeah. It was never about interfering. It was all about the camera. And they lie about it constantly. Well, you can film wherever you want. You just got to film all the way over there where you can't see or hear us because we're going to violate your constitutional right. Yeah. So let me kind of explain what happened between Chille's case and Sacramento's case. So when it went through the magistrate court or the municipal court, because Chief England's went through Reno PD, and Delete Laws Chille DeCastro went through Vegas PD and municipal courts. So the municipal courts on Chille's side, Chille did not take his own advice. He did not follow his own rules. And he knew better walking into that courtroom that when you walk into that courtroom, you play by the court's rules. There is no ifs, ands, or buts. Everything, when you walk past the door, even as a spectator, all rights are put on hold pretty much. You do not have the freedom of speech in that room. You can't call the judge a moron or a liar or, just shout out in the courtroom. You can be held in contempt of court for that. You don't call people names. And you don't raise heck in the courtroom. Chille DeCastro did. And he knew it. And he was really sorry about it. And he went to jail for 40 days. And he was sentenced to, I believe, 90 days, 60 or 90 days. He had 2 counts, one interfering and one resisting, I believe. Not 100% on the details. I didn't quite look him up before I came in. But you can check out his channel over at Delete Laws. And, go through that as well. I'm not going to get into that. So what wound up happening is when Chille got sentenced, we were next. Sacramento Community Watch's Chief England was next on the exact same thing of resisting a public officer. Now, we were kind of worried that, Chief England was going to get a raw deal out of this based upon what happened on Chille's case, because the cases are relatively similar. I mean, you've both seen it. I mean, other than that, we didn't have a suspect, and Chille did. We had a victim. It was about filming within a certain amount of distance. Now, Chille went to jail because he called the bailiff or the sheriff in the courtroom a tyrannical pig, and basically argued with the judge about his phone being taken away from him when, he wasn't going to use it. Which, again, is seizing, in my opinion, illegal search and seizure. Because you're searching for people's phones and then you're taking them away from them. But, again, your rights are a little bit suspended when you walk through that door. So, Chief England had his day in court. Go watch the live streams. And they sentenced him to a deferred sentence of, I believe, 30 days if he kept his nose clean for a year. So he avoided jail time, but he was still found guilty, just like Chille was. Now, while Chille was sitting in jail trying to appeal, Sacramento Community Watch, Chief England, was trying to get out all the money and everything caught up, because apparently you have to pay $1,000 bond fine and a little bit of court costs. So there was about $1,000 there. And we had to get they had to get transcripts. And I want to use we a lot because I've been kind of with him and supporting him through this a bit. So it kind of feels like we are going through this together. But what wound up happening is Chille wound up going up to the next court, the district court in Nevada, and this is what the judge had to say.
But otherwise, I have nothing else.
Okay, so this time the court's going to grant the appeal and reverse the convictions based on its First Amendment protected conduct. And Mr. Orm, you can prepare the order.
Yes, ma'am. Thank you very much, Joe.
He needs to be released from custody, so
He'll be released immediately.
we'll
No.
Thank you.
Thank you.
Okay, and folks, it took Chille a couple of days afterwards to get released as well. I mean, when a judge says release him, an hour, in my opinion, but that's beside the point. So Chille's case was overturned, and he's a free man, but he's never going to get those 40 days that he spent in jail back. And there's going to be a lot of court cases to come off of that. Now, I want to go through a few things with Sacramento Community Watch. And let me pull open this screen here, and let me go ahead and share this screen instead here. So, yep, that's the portal. Okay. So this right here is Chief England's case. And like I said, you know, they got my sworn testimony, and, you know, he had his case on April the 1st. And, you know, they basically he had to have a payment plan where he paid back the public defenders. Defendant has a right to appeal. He have to post $1,000 bond. I paid for an audio recording of that court case, and we covered it in our live streams. And then we got the appeal notice of appeal file within minutes of them closing on April notice of appeal filed. Okay, so the Mr. Edgerton, his public defender, filed a notice of appeal. Deposition reported, filed in district court. Well, he paid. I forgot what day he paid it, but we're going to go over that. You know, it's in the notes here. Defendant. Okay, so what we're going to cover next here, and let me just switch screens real quick, is his appeal for the transcripts. So the way it works is when you go to the higher court, where is it? One. Okay, ex parte motion. So when you go to when you go to the higher court, you have to provide transcripts. We're going to cover it. There's certain things you got to do, and one of them is to get the transcripts from the lower court. Now, you may not know this, but you know that court stenographer that's sitting there typing away at their little mini keyboard thing that, you know, they basically record, you know, it's typing sounds. They're not typing out whole words. It's really interesting. It's really weird, and I've met a couple court stenographers before I got into First Amendment auditing, and they were pretty cool. But, you know, we're filing an ex parte motion for transcripts on this page here. Let me pull it up over here so I got it here. So ex parte motion for transcripts. We're basically saying, because Mr. England can't pay for his defense, for whatever his reasons, I'm not going to get into it, but he has indigent status with the court. So he got a public defender, and it means that he's entitled to certain things for having an indigent status. So that's basically what we're doing. Is defendant moves this court ex parte for an order authorizing a preparation of transcripts in this case at public expense. Please see attached exhibits 1 and 2, memorandum for points of authorities, and number 2, the application for appointment of a legal defender. And then it has Mr. Edgerton's signature on there. So that's pretty much boilerplate. Ex parte means that, you know, ex parte means that they are not involving the other side. We didn't want to involve the other side. We're basically saying, hey, we need transcripts if we're going to go and appeal this. And that's basically what happened. So I'm going to go ahead and pull up the second page here, the addendum. Let's see, that was 1. There's number 2. Okay, so the ex parte. So here's exhibit 1. Now, and I did redact some information out of here that just doesn't need to be public at this time. But again, these are public documents. If you feel like you need that information, go to the court, file it. So The defendant was convicted on one count of obstructing an officer on April 1st of 2024, and he has appealed his conviction to the district court. The defendant has posted the required appeal bond of $1,000. The undersigned counsel contacted this court's designated transcribing service to learn that the cost of preparing these transcripts for this approximately 3-hour bench trial, based upon quoted rates of $35 an hour and an estimated time of 9 hours, with $4.25 per page. The estimated length is 360 pages. Counsel believes that the cost of the transcripts could well exceed $1,500. The defendant has informed counsel that he isn't able to absorb the cost due to his economic circumstances. Counsel was appointed to defendant's case on the basis of the defendant's indigency, and the condition continues at the appellate stage. Attached as Exhibit 1 is an application for an appointment of a legal defender completed by the defendant under penalty of perjury. Upon request of the party on order of the trial court, the court reporter must prepare a written transcript of the recorded proceeding. The court reporter is entitled to compensation for preparing such a certified transcript. A party not otherwise able to pay for transcripts necessarily to their appeal has a due process entitlement to the preparation of transcripts and the provision of copies. Basically, due process, folks. Love that. Due process. Even though you can't afford it, you're still entitled to due process. Additionally, Nevada statutes requiring preparation and filing of transcripts with the court clerk and providing compensation, including at public expense, for such transcripts authorizes this court to order the transcripts to be furnished at public expense. Based upon foregoing, defendant moves the court to order the preparation of the transcripts in this case at public expense. And then here's an affirmation that it does not contain social security numbers, blah, blah, blah. And then there was Exhibit 2, which was his application, which, again, I don't want to show it here, folks. It's not necessary. Again, it's public information. If you feel that you want it, please feel free to file with the courts and get that information. So let's go ahead and share the next window. Okay, so sorry about that, folks. A little bit of cotton mouth there. So what wound up happening is the court basically didn't want to do this ex parte. They wanted to involve the city. So they scheduled a hearing on it. But before they did that, I think they reached out to the city to let them know. So again, Municipal Court of Reno and County of Washoe, State of Nevada, Walter England versus City of Reno. It says here, on May 6th, petitioner Walter England filed a motion for ex parte motion transcripts. The court has reviewed the motion and finds it would assist the court for respondent, City of Reno, to file a response. So they're basically saying, yeah, even though this is ex parte, we still want you to be involved in this. We don't need you to be involved, but we would like you to be involved. Let us know and give us a response. So after which the petitioner will be entitled to file a reply, that's what court is basically, folks. You file a bunch of legal documents that say, hey, I'm right, and here's why. The other side files a bunch of legal documents that says, no, they're wrong, I'm right, here's why. And then the original party comes back, gets all those, and gets a chance to reply and go, they're way off base. They're completely wrong, even though they're saying I'm wrong. And here's why. And then they all go to the judge. The judge sits there and listens to it in front of a jury sometimes. And then the judge or jury makes a decision as to who's right. That's what courts are, folks. So we're kind of going through those motions here. Petitioner will be entitled to file a reply. Once the motion is fully briefed, the court will consider it and issue an order. Based upon the foregoing and good cause appearing, it is hereby ordered that the city of Reno shall file a response no later than May 20th, and is further ordered that petitioner shall file a reply no later than May 30th, so ordered the 9th day of May. So here it is, 9th day of May, and we're already pushing this appeal out all the way out to the 20th of May. The judge could have said, yep, he's based upon everything I know and see here, we don't need to involve the city of Reno. File the transcripts, let's get going. But no, they're going to push this off until May 20th at the minimum. I mean, because they still have to schedule and have a hearing eventually. So that was that. Let me stop sharing that. And let's get the next one. So that was 4. This is 5. Okay. So this is reply. This is their reply. Let me go back up to the top. Okay. State of Nevada versus Walter England, the Municipal City Court of Reno. Okay. Opposition to ex parte motion for transcripts. The plaintiff, the city of Reno, by and through counsel Carl Hall, who's Reno City Attorney, and Leann Schumann, Deputy City Attorney, respectfully submits this opposition of ex parte motions for transcripts filed on or about May 6th by the defendant's attorney of record, Kyle Edgerton. This opposition is based upon the points and authority set forth below in all the pleadings on papers on file with the court in this case, and the arguments to be heard at any hearing upon this matter if a hearing is necessary. That's not what I'm showing on my screen. What am I showing? I'm showing 5. Let me fix that, guys. I'm sorry. I must have hit the wrong thing. Share screen, window 4. There we go. So they already oppose it. Now here's why. Points and authorities. Within its motion, the defense requests the court pay the cost to prepare the transcripts for the defendant's appeal. The U.S. Supreme Court has held the city is not required to furnish a transcript in every case involving an indigent defendant, in quotes. Do you see this here? The city is not required to furnish a transcript in every case involving an indigent defendant. See Eckridge v. Washington Prison, BD, and Griffin versus Illinois. Thus, the court should not pay the cost to prepare the transcripts in this case. Now, here's the thing, folks. I am not a lawyer. I've said so before. There's a disclaimer at the very beginning of the video, folks. I'm not a lawyer. Play one on YouTube here. So here's the thing. I went out and asked Gemini, Google Gemini, if they can explain if they could explain those two cases for me. And it did. And let me find Gemini. Oh, there it is. Okay. So let me see if I can make Gemini a little bit bigger here. And can I hide this? Collapse menu. Yep. Okay. It says in Eckridge versus Washington Prison, the Supreme Court of the United States held that the state's denial of a transcript to an indigent defendant for the purpose of appeal violates the Due Process Clause of the 14th Amendment. The case arose when Eckridge, an indigent defendant convicted of murder, was denied a free transcript of his trial proceedings. The Washington Supreme Court dismissed his appeal for failure to file a transcript. Again, the courts want a transcript. The Supreme Court reversed Washington's Supreme Court decision, finding that the state's denial of a transcript effectively denied Eckridge his right to appeal. The court relied on its earlier decision of Griffin v. Illinois. And we covered Griffin v. Illinois in that one. She mentioned that one too. which held that the state cannot deny an Indigenous defendant the right to a transcript for purposes of appeal. The court reasoned that the right to appeal is a fundamental right, and the state cannot deny the right to an Indigenous defendant simply because he cannot afford to pay for a transcript. The court further held that the state's interest in preventing frivolous appeals does not justify denying a transcript to an Indigenous defendant. Eckridge v. Washington Prison is an important case because it established that the Due Process Clause of the 14th Amendment requires the state to provide Indigenous defendants with the necessary means to exercise the right of appeals. So already, and let's go back to that screen that I was sharing earlier. Let me go back here and share it again. Number 4. She totally misrepresents those cases. You know, and again, before she was a deputy prosecuting attorney for the city of Reno, Nevada, Miss Schumann was, I got it up here, a child custody attorney. So while this trick may work for child custody, I don't see this working where she's representing the state. And if this is how she's representing the state, it's poor. Her as a prosecuting attorney is the gatekeeper between what the police are doing that's unconstitutional and what's constitutional and right and wrong in the law. And if she sees that this is unconstitutional, and she's supposed to look into like, oh, this magic crystal ball of her legal profession and knowledge to find out whether or not it is or not. And, you know, everything that I brought up, you know, legal-wise in the case, which of course there's not much when it comes to distance, you know, she asked if any of that had anything to do with Nevada. I mean, the closest thing that comes is the Arizona, you know, law that they got struck down, which was 8 foot or 10 foot. You know, it's like, so, you know, yeah, it's the court, even though they haven't said, oh, you have to stay this many feet away on both sides, PD and auditors, they've never established a clear-cut distance. So keep that in mind. So she's already got this wrong. This Eskridge, Washington, PV, and Griffin, Illinois. Now, if they weren't appealing and still just wanting the transcript, yes, they don't have to provide a transcript for every Indigenous status, but if they're appealing, they have to. Okay, so continuing on with her opposition to the motion, defense has not provided good cause as to why a written transcript is needed or how the defense would be prejudiced without the transcript. Alternative trial methods, including trial audio recording, are available at little or no cost to the defendant. The defense also submitted an upon statement of facts within the appeal pursuant to NRS 270.101 without the necessity for a trial transcript. The defense is arguing legalities, such as whether a physical force is required for obstructing and resisting, as it did during the trial. There is no need for a transcript. It is not necessary for the city to waste limited funds to provide transcripts that are not necessary for adequate appellate review. Draper versus Washington, 372 U.S., so on and so forth. Now, let me see if I can find that again. Let's see, NRS 270. Okay. I don't have NRS 270 yet. But what I do have is Griffin. That was Griffinville. Draper versus Washington. Let me pull that up here for you. So let me just kind of go over a few things here with it. So she's basically saying that we don't need transcripts for your appeal. We got the court audio. You know, that's available, and then we shouldn't waste limited city resources and funds to do all this stuff because, oh my gosh. Well, here's the thing. The city of Reno has a lot more money than Miss Schumann is letting on, folks. A lot more money. As a matter of fact, the fact that she's crying about money, about Reno crying about money, she should be worried about whether or not she's going to have a lawsuit on her hands at the end of this once it's dismissed. And then she should worry about whether or not she has a lawsuit from Officer Hoyt when he got arrested the first time Chief England did. So Draper versus Washington. I asked Gemini about that too. So let's go ahead and do that here. Let me pull back Gemini up again here. So I asked Gemini to explain Draper versus Washington. Gemini states that it's a significant Supreme Court case that established a standard for determining probable cause based on information from an anonymous informant. So again, she's going off that, we're complaining that we have no probable cause. Give me just a few moments here, folks. Yeah, what's up? What? No, it shouldn't hurt you to take naproxen. Okay, I'm back. My spouse, Mr. News now, had some medical issues, and he had emergency surgery, and he was wondering about a medicine. So he was wanting naproxen. So anywho, so she's saying that we're arguing that they had no probable cause for the arrest, which is true. He had none. There was no probable cause. There was no resisting. There was delaying. There was no, if you go back and watch the body-worn camera footage that we did, he was Tony the Tyrant, Mr.
Am I going to be famous too? You're going to put me on your YouTube video?
Yeah, he's Mr. YouTube video it had no probable cause to arrest him in the first place. So she's trying to say that we have no probable cause, and that this right here is a court case as to why you should dismiss it because he had no probable cause in the first place. So let's go back and share that screen again to the opposition. Okay. Notably, this defendant is out of custody, unlike defendants in the Supreme Court case of Eckridge versus Washington Prison Boulevard and Griffin versus Illinois. So she's saying that because he never went to prison, he wasn't in prison, he's not serving jail time, he's not really indigent. He shouldn't really have access to the transcripts because there's no need for him because, he's not been in jail. He has not been harmed. Well, he has been harmed. She goes on to say, usually the transcript is only paid for defendants who are stuck in jail and prison and have no ability to generate income, which is not the case for this defendant. Ms. Schumann, you need to go back to prosecutor class. People can be indigent without being in jail. And you are pushing the boundary, in my opinion, of malicious prosecution. Again, I'm not a lawyer, I don't claim to be, but if I've ever seen a case for malicious prosecution, this is it. Would I go to law school to do this? No. The defendant is choosing only to work part-time at Denny's for only 21 hours a week. Now, we'll get into that a little bit more, but he's not choosing to. That's all they would give him. He wanted to work more hours, I'm sure. But how can you work more hours when you're only given so many? Finding a full-time job in and of itself can be a full-time job. When you're working a part-time job, how can you go find a full-time job when you're having to work a part-time job that won't let you go out and find one full-time, She goes on to say he is single, has no dependents, and is not a student. He receives Medicaid benefits. No documentation has been furnished to prove any of this information. And yet you are trying to enter it in as evidence into court. You have no evidence of this, so why are you even bringing it up? The defendant is grossly underemployed, assuming to receive state Medicaid benefits. Again, she's assuming. She just made an ass out of herself. Assume. ASS, you and me. You know how you make an ass out of you and me? You ain't making an ass out of Mr. England. You're making an ass out of yourself. And who cares if he receives state Medicaid benefits? He would have never been in this position if Mr. Tony the Tyrant knew the law. Know thy law, thy officer. The defendant has also created a GoFundMe page to donate, to get people to donate money for this appeal. Now, yes, the Sacramento Community Watch team has a GoFundMe page for all of our legal expenses, if we occur any. Even to this day, it only has $10. Mr. England did not make this GoFundMe page. So right there, she's lying. Mr. England is nowhere on that page. It's my mug asking for money, talking about Mr. England. What's going on? And I put in the first donation of $10 to that fund. And to date, it has not gone any further because we're too small of a channel. We're growing. We want to grow. We want to grow the Sacramento Community Watch. We want to make it better. We want to put more content on there. But if we're doing these things, stuck in legal proceedings, we can't do it. We can't do it effectively. So she's putting us through this as malicious prosecution, in my opinion. The defendant has an ability to work to save more money for transcripts. He could start working full-time or get another part-time job. It should also be noted that the defendant was able to pay the $1,000 bond with no issues. Okay, so here's the thing. With the amount of time that the courts allow you to deal with this, there is no way in heck Mr. England at the time could have been able to raise another $1,500 to pay for court transcripts. There's just no way. It was not going to happen. And the $1,000 bond, I'm not going to get into that, but it was secured last minute, and it will be addressed in the rebuttal of this. So I'm just going to leave it at that. So the conclusion, based upon the following, the court should deny the defendant's ex parte motion for transcripts respectfully submitted on this 14th day of March or May 2024, Carl Hall, City Attorney by Leann Schumann. So Leann Schumann is signing off on this for Carl Hall. An affirmation that there's no personal information in there, certificate of service, basically legal boiler or court policy that information is put on there. Okay, so that was number 4. So you know what that means. We filed our motion, they filed their opposition, now we get to rebuttal. So let's pull up the rebuttal. Share screen, and that would be number 5. In reply. Yep, there we go. Share up. Let me go back up to the top on this one. This is the one that you guys were seeing at the beginning. Okay, so defendant's reply in support of motion for preparation of transcripts at public expense. The defendant, Walter England, through the appointed attorney Kyle Edgerton, submits this reply in support of his motion in preparation for the transcripts at the public expense. This reply is based on all papers, pleadings on file with the clerk of court, which are incorporated by reference and the attached points, so on and so forth. And oral arguments at any hearing this court may deem necessary to hold over the matter. Okay, so memorandum of points and authorities. Justification for ex parte motion. The defendant initiated this motion as an ex parte request for an order of transcripts, in this case, be prepared at the public's expense. So This was done in keeping with the undersigned counsel's practice in appellate and trial court matters on behalf of indigent defendants. This widespread practice protects the deliberative aspect of a defendant's strategy from observation by his opponent, the state, or here, the city. So basically what Mr. Edgerton is saying is that the city don't need to know what's going on with Mr. England's or Chief England's indigent status. There's just no reason behind it, because at this point the court and the prosecuting attorney could use it against him, which they were trying to do in their previous motion, trying to use his indigent status against him. One reason to maintain privacy is the asymmetry of power between the city and the defendant. Oh yes, there's such a big asymmetry. The city with unlimited resources that Ms. Schumann says are finite, and Mr. England's resources, which are truly finite, now forced to go into court, which makes him infinitely finite. Interesting. Whereas the city has functionally limitless resources to bring to bear in any one prosecution, a defendant is limited to his own modest means. Ain't that the truth? Hallelujah, Mr. Edgerton. If the city has insight to the extent of the defendant's resources, it can determine a point at which the defendant can no longer afford to mount a defense and potentially secure a conviction or hear a victory on appeal, not on the merits, but rather by exhausting the defendant. So this is it to a T. We cannot win on the merits, so we're going to exhaust you financially. Malicious prosecution. A little bit much, is it not? Again, this is the court of public opinion, folks. Public documents, public venue, public opinion. If you have a problem with this, please contact the city attorney's office. Details can be found at reno.gov. Excuse me. Oh, thank you. Okay. The city's opposition to this motion also illustrates how a defendant's financial circumstances can be weaponized against him as he attempts to vindicate his statutory and constitutional rights. The city assails defendant as grossly unemployed, and speculates that his part-time employment is by choice and calculated to receive state Medicaid benefits. Opposition at 2. The city also notes the defendant managed to post his $1,000 bond necessary to secure his appellate rights with no issues. Opposition at 3. In fact, the defendant posted this bond mere minutes before filing the filing deadline after securing an emergency loan. I can tell you folks, I thought the court closed at 5 o'clock when we turned in this $1,000 bond. I had to drive Mr. England to the courthouse. We were rushing. I dropped him off on the courthouse steps while I went to find a place to park. Court closed actually at 5:30. So we posted that bond within half an hour of them closing. That's how close we were cutting it, folks. So mere minutes is true. The city also mentions a GoFundMe fundraiser, which defendant originally hoped would finance the appeal bond that has raised $10 in the 5 weeks since it's been active, and then posted this. Still only has $10 in it, folks. Please donate to the GoFundMe. As a matter of fact, you can also donate to Cash App or Sacramento Community Watch's Cash App. Details are down in the bottom in the description. The defendant filed this motion ex parte, meaning without the other side having to know, in keeping with established practice to avoid the dynamics noted above. So Mr. Edgerton filed this ex parte so they didn't have to involve the city of Reno, who is now weaponizing Chief England's indigent status. Sad, ain't it? Again, the defendant filed this motion ex parte in keeping with established practice to avoid the dynamics noted above, not in an effort to hide anything from the city that has meaningful interest in observing and commenting upon. Now, 2, the need for the transcripts. The city argues that the motion should be denied in part because, quote, defendant has not provided good cause as to why a written transcript is needed or how the defendant would be prejudiced without the transcript, end quote. To the contrary, defendant understands applicable law potentially permit his to potentially pretermit, I'm not sure what that word means, his appeal if he does not provide transcripts. Pursuant to NRS 5.073, procedure in the Reno Municipal Court must conform as nearly as practicable to the practice and proceedings of justice courts in similar cases. Per the applicable justice court rules, a transcript of the trial court proceedings shall be transmitted to the district court along with other components of the original record. However, the Nevada Supreme Court has clarified that the transcript referenced in NRS 189.030 is only the transcript, if any, already on record with the trial court. If no transcript exists, then it's the responsibility for preparing the transcript falls on the defendant. A district may dismiss an appeal solely on the grounds that the defendant failed to furnish required transcripts. Thus, the defendant requires transcripts in this case to avoid the risk of having his appeal dismissed out from under him. And Mr. Edgerton is right. Again, if Ms. Schumann knew this, again, she's child custody. What was it here? Yeah, child custody attorney in Nevada before, according to her AVO website. Child custody for licensed for 12 years. So I'm not sure how long she's been working with Reno PD. I suppose I could open records, request her employment record, salary. I can request her oath of office because I'm pretty sure she's not adhering to defend the Constitution like she should be on this case. But that's just my opinion. Anywho, so let's see. That was NRS 189.30. I want to go over that real quick, folks. So let me switch screens here to this, to Justa. And again, NRS 189.30, transmission of a transcript, other papers, sound recording, and copy docket to district court. To district court. This is a law. Know that law, prosecuting attorney. Come on. The justice shall, within 10 days after the notice of appeal is filed, transmit to the clerk of the district court the transcript of the case and all other papers relating to the case and a certified copy of the docket. Justice shall give notice to the appellant or the appellant's attorney that the transcript and all papers relating to the case have been filed with the clerk of district court. And if the district judge so requests, before or after receiving the record, the justice of the peace shall transmit to the district judge the sound recording of the case. So yeah, they're required by law to provide them. So let's go ahead and go back to that, what we were doing. Window 5. Okay, sure. Okay. The city proposes an alternative that the parties rely on hearing audio. Defendant identifies 3 problems with this proposal. First, it's not clear that this proposal will satisfy the district court, which may strongly prefer A, adherence to the procedures outlined in Chapter 189 of the Nevada Revised Statutes, which we just read, and B, a written record that can be reviewed more expeditiously than an audio recording. Yeah, because when you write your appeal, look at page 20 of this, line 4, boom, right there. They said this. And then you're going to ask the judge, hey, can you go into the audio recording, go to 4 minutes and 53 seconds, and then 10 minutes and 28 seconds, and 1 hour and 45 minutes, and listen to all these little snippets? No judge is going to want to do that. They got enough on their hands. He's got to read through stacks of papers. No judge is going to take time to open up a computer and watch this before the case. I agree with Mr. Edgerton. Ms. Schumann is just, oof. Okay, so the city's final proposal that the parties stipulate to a common set of facts even is more likely to be penny wise and a pound foolish. The time and energy required for the parties not only to listen to the hearing audio, but also attempt to determine a shared set of material facts, also to negotiate how those facts would be reduced to writing and presented to the district court, is certain to consume more attorney time than the $1,500 at issue at the request. Basically, Ms. Schumann was asking, can we play Kumbaya and just give them the records and just move forward and forget about everything else? And just come to agreement that, what was said in court was said in court? No. For one, Ms. Schumann, your one of your star witnesses, Tony the Tyrant.
Am I going to be famous too? You're going to put me on your YouTube video?
Wasn't able to answer what a lawful order was, and you objected to even the question. He's out there giving lawful orders left and right. You should see some of the videos that Sacramento Community Watch channel has posted about this tyrant and how he's spouting off lawful orders that are truly unlawful. Reno PD needs a re-education on the law. They spend too much time on their guns and not enough time on the law. My opinion. For these reasons, the court should conclude that the transcripts as requested are necessary and cannot be substituted simply to avoid the requested expenditure. Number 3, defendant's right to a transcript at public suspense. The city contends that the city is not required to, quote, furnish transcript in every case involving an indigent defendant. Opposition at 2. This claim relies on selective reading of the quoted passage. Again, selective reading. Ms. Schumann is trying to play to the biases of the judge, that the police can do no wrong. We know what we're doing, just like the last judge did, who got it wrong. And that's why we're appealing. He relied on officer safety. There is no law on officer safety, folks. Just remember that. No law about how far a person should be away from the police when recording, and there's no law about officer safety. It is case law, and you have to engage the law before case law kicks in. You have to have somebody detained or have somebody be a suspect in a crime in order for the law to kick in, and then once it does, then officer safety kicks in. Until then, he is nothing more than a glorified public servant allowed to carry a badge and a gun. Yes. The claim relies on selective reading of the quoted passage. Quote, we do not hold that a state must furnish a transcript in every case involving an indigent defendant, period. But here, comma, as in the Griffin case, we hold that destitute defendants must be afforded as adequate appellate review as defendants who have money enough to buy transcripts. So yes, while the state must not have to furnish a transcript in every case. If the person does not appeal, they do not have to get a transcript. But if they decide to appeal, the state must provide a transcript if the defendant cannot assume to the responsibility of payment for one. Again, go back to family court. These kind of tricks work in family court. They do not work in criminal court. The judge should just laugh you out of the room, Ms. Schumann. So silly. Likely through its inadvertence, the city misrepresents the relative holding. The holding is not that certain indigent defendants are not entitled to transcripts on appeal. Rather, the holding is that where a transcript is required on appeal and where denying a defendant's request for transcript at public expense is necessary to ensure equal justice irrespective of a defendant's financial means, the transcripts must be produced. Exactly. Even if the city's framing of Eskridge were more accurate, defendant would further note that Eskridge and the Griffin case, upon which it relies, were decided before the right to counsel for an indigent defendants was established in Gideon versus Wainwright. In the wake of Gideon, defendants' claim to publicly funded transcripts necessary to his appeal is even stronger. For these reasons, this court should conclude that the defendant is entitled to transcripts prepared at public expense as an extension of his status as an indigent criminal defendant. And the conclusion, for the foregoing reasons, defendant again asks this court to grant his motion to have transcripts necessary to his appeal prepared at the public expense due to his inability to pay the estimated cost of $1,530. And again, more court procedure boilerplate on there. So, with those two out of the way, they did hold court over this. And I did request the court audio, so we're going to go back over that again later. Unfortunately, I did not get it in time for this live stream. I've asked for it because I've already paid my $35 to get the court transcript, and they only gave me that one day. When I put the request back in, I asked for this hearing that covered this, as well as the judge, when I asked for my media access before, right after his arraignment, because I asked during his arraignment, I was denied, and I asked again with this judge because I thought that was the right thing to do. He denied me, which is fine, and he says, this ain't the proper venue to ask for you to have me overturn. I'm not going to overturn one of our own judges. He goes, you need to go up to the next court. I had to go up to the court that, the county court, to have them overturn it. Unfortunately, I'm not going to pay money to have that done. But what he said afterwards, and what I want you guys to hear, is him saying, I am not going to let you defame the police department. That's what I want you to hear. And I will have that video along with some other news on that, because I did do something within the legal system with that judge. And that's something you have to like, share, and subscribe for. So that'll come in another video once I get the court audio back. We'll go over me and my tip with the judge, and just to make sure I have his name right. Oops, where is the judge here? Legal department. I'm just trying to find the judge. Oh, Officer Draculich. Yeah, Gene Draculich. Judicial Officer Gene Draculich will not let me defame the Reno PD. So, Chief England went to court over those motions, and the judge basically sat down and he goes, I know how I'm going to rule on this already, based upon everything that was given to me. And he goes, I even went across the street to the district court and talked to a few people over there and see what our options were and what we could do. And I've already know what I'm going to do. And I'm just going to listen to motions real quick and see if anything new comes up, and we'll go from there. And basically he asked the prosecuting attorney, do you have anything else? And she goes, no, we just ask that you deny it because, there's other means, and basically kind of a little bit rehashing, if I can remember, of what happened there. And then, or Mr. Edgerton came up and was talking as well, and basically said, yeah, no, the city has it wrong. You need to provide these transcripts. And thank you guys for joining in. Please like, share, subscribe, leave a comment. But yeah, just downright stupid. And we're going to get you that audio, that court audio. But the judge says, yeah, my hands are pretty much tied. We have to provide the transcripts. There's just no way around it. And it's so ordered. So that's what wound up happening there. So during this process, we're still, Chief England and Mr. Edgerton are still trying to appeal this case. So they filed motions in appeals court, and or there were some motions filed in appeals court, and we're going to share those with you now. So, and again, it kind of goes down to what is Miss Schumann trying to do here? It makes absolutely no sense. And it's only pushing the narrative of malicious prosecution even more. And what it seems like she's trying to do is get this case squashed, get it thrown out, just so she can avoid the potential civil rights violations that's coming up here. Because you've all seen what happened with Chille's case. On appeal, his case was dismissed. It was gone. They basically said that he had a First Amendment right to do what he did, and the cop messed up. He messed up royally, and now there's a civil rights lawsuit. And now here's the thing, folks. Nevada in itself does not have qualified immunity. So what that means is there's still federal qualified immunity and there's state qualified immunity. State qualified immunity is gone. No cop has it here in Nevada. So if we wanted to, or if they wanted to, they could go in and file in Nevada and go after them. And they can do it federally. As a matter of fact, I think they might be able to do it federally and then do it in the state. I'm not sure. I'm not a lawyer. We need a civil rights lawyer to look at both of these cases and help us out with this. If you do, please contact us in the links below, or our email addresses. We greatly appreciate it if you guys know a lawyer. So we're going to go over now the appeals on or the appeals court. And Carl Hall and Ms. Schumann filed a motion to dismiss appeal for failure to request a hearing within 60 days. And here's the BS tricks that they're trying to do here, folks. So comes now the respondent, City of Reno, by and through Leann Schumann, Deputy City Attorney, and files a motion to dismiss this appeal an above captioned case. This motion is based upon the pleadings and documents on file herein and the following legal argument. The appellant is represented by counsel Kyle E. Edgerton, Esquire. Shout out to Mr. Edgerton. Love to have you on after everything's settled, but again, wonderful attorney. Even if he is a public defender, I would love to see him possibly becoming a special prosecutor if necessary on this. It would be awesome. But again, that's just my opinion. So the legal argument. So on April 1st, the Reno Municipal Court convicted appellant of resisting public officer NRS 199-280, again, contempt of cop, unconstitutionally written contempt of cop. And again, the cop doesn't know the color of law.
Do you see the color that I am?
Anywho. After the trial was held, the defendant was found guilty. See municipal court proceedings filed on April 19th, 2024. On April 9th, the defendant filed a notice of appeal on this matter. See municipal court proceedings. And then, pursuant to NRS 189.065A, appellant must perfect his or her appeal by requesting a hearing within 60 days of filing their appeal, otherwise by June 9th of 2024. And if the appellant fails to perfect his or her appeal by requesting a hearing within 60 days, the appeal must be dismissed. Okay, so 189.05. I believe I have that up here. 189.65. Okay. 185.65. Okay, let me pull that up for you guys. So present, share screen. Here. Sure. 189.065. Dismissal for failure to set or reset appealing for hearing. An appeal must be dismissed by the district court unless perfected by application of the defendant within 60 days after the appeal is filed in the justice court by having it set for hearing. If an appeal has been set for a hearing and the hearing has been vacated at the request of the appellant, the appeal must be dismissed unless the application is made by the appellant to reset the hearing within 60 days after the date of which the hearing is vacated. So yeah, it's just basically a way for the court to clean up old hearings. It is the way that reads. You know, there's still other things that are going on in that case. So let's go back to her dismissal claim here. Okay, Nevada law is clear that a rule is mandatory and requires strict compliance when the language states that a specific time and manner for performance, Markowitz versus Saxon Special Servicing, time and manner refers to when performance must take place in the way in which the deadline must be met. And here's the fun part, folks. Listen to this. Ignorance of the law does not justify failure for such a litigant to follow the law. See Rodriguez versus Fiesta Palms. Ignorance of the law does not justify failure for such a litigant to follow the law. Two-way street, Miss Schumann. Two-way street. What's going to happen when Walt has been proven innocent in this case? Are you going to go after Tony the Tyrant for felony felony deprivation of rights under color of law, misdemeanor, NRS 171.1233, filming an officer, NRS 171.123, detainment, sections 1 and 2. Should I go on? Assault. If he's not being legally arrested, it's assault. So, Ms. Schumann, are you going to go after Tony the Tyrant if Walt clears his name? Because ignorance of the law does not justify failure to follow the law. Continuing on. Even a pro se litigant cannot use his alleged ignorance as a shield to protect him from the consequences to failing to comply with the basic procedural requirements. Even a law enforcement officer cannot use his alleged ignorance as a shield to protect him from the consequences of failing to comply with basic procedural requirements. Again, Ms. Schumann, are you going to go after Tony the Tyrant for breaking the law if Walter England, Chief England, has been proven innocent by the appeals court? Like a yes or no answer on that. And I guarantee you I know what the answer is. It's going to be no. Because back the blue until it happens to you. That blue line, thin blue line BS. Anyways, the appellant in this case has legal counsel who's been practicing law in the state for Nevada for several years. Therefore, the appellant should be held to the standards of appeal procedure. Though the respondent stipulated giving the appellant more time to complete his opening brief, the 60-day rule was not told and remains in full force and effect. So even though the respondent, them, stipulated giving the appellant, us, or Walt, or Chief England, more time to complete his opening brief, they're still saying the 60-day rule still applies. Oh yeah, you can have as much time as you want. Go ahead. Oh, by the way, in 60 days, we're coming and filing this brief, which is what they did. Accordingly, the appellant's failure to file the requested hearing within that time is deemed an admission that the appeal was not well-founded and constitutes adequate grounds for dismissal of the appeal, such the appeal should be dismissed. Again, this is family law. This reeks, that paragraph reeks of family law, in my opinion. Again, I'm not a lawyer. I haven't really read through family law. But this seems like a trick that you would use in family law. Oh, my wife's attorney or my husband's attorney did not file the brief in time. Therefore, it should be dismissed. Give me my house. Give me the car. Give me the kids. Go back to serving kids, Ms. Schumann. Quit serving the city. You're not serving the city. You're not doing any good. weak sauce arguments. Based upon the foregoing, the respondent respectfully requests this honorable court enter an order dismissing the appeal. Again, folks, please like, share, and subscribe. Again, this is boilerplate for the rules of the court. I am who I say I am, and I do not put any personal information that could be crucial, like social security numbers. Okay, appellant's opposition to the motion to dismiss by Mr. Edgerton. I love reading Mr. Edgerton's work. I love it. Oh my God. Puts Ms. Schumann in her place right off the bat. Appellant Walter England, through counsel of Kyle Edgerton, submits its opposition to Reno's motions to dismiss the appeal for failure to request a hearing within 60 days, filed June 24th of 2024. The opposition is based upon everything with the clerk of court, and attached points have been put in here, and the court may deem necessary in this matter. So anyways, going on to the facts. Statement of facts. This case is an appeal from the appellant's conviction in the Reno Municipal Court, the RMC, of a single offense of resisting a public officer, aka contempt of cop, in violations of NRS 199-280.3. The RMC case was heard twice post-arraignment and concluded with hours-long bench trial on April 1st. Following his conviction, appellant was given a suspended jail sentence, and the RMC also encumbered him with a $1,000 bond obligation should he seek the appeal conviction. Thanks for joining in, guys. Please take a moment to like, share, and subscribe. An appeal from a conviction in the Reno Municipal Courts must be taken within 10 days. So once they've sentenced you to judgment, you got 10 days to get your appeal filed and get the bond set, so that way we can continue. An appellant filed his notice of appeal with the Reno Municipal Court on April 9th. However, he was not able to post the appeal bond at the same time due to his indigency and inability to qualify for a traditional bail bond. The RMC could not fulfill its obligation to transmit the record to this court case within 10 days unless the bond was posted. With minutes to spare on the date of the deadline, again, minutes to spare, folks, the appellant posted the bond on April 18th. The RMC then transmitted the record to this court on April 29th. So 11 days later, Reno Municipal Court transmitted the court filings after he posted the bond, and 20 days after the original appeal. Appellant next turned to his obligation to obtain transcripts for the record on appeal. After the cost of preparing the transcripts was estimated in excess of $1,500, the appellant filed an ex parte motion in the Reno Municipal Court seeking preparation of the transcripts at public expense, again due to indigency. And we just read that, folks. The RMC did not resolve the motion on an ex parte basis. Again, they wanted to drag this out in court, and instead invited a response from the city of Reno, which vehemently opposed the request. And oh boy, did she. And she had every legal case just about wrong on it. And again, she's just about wrong on this one too, folks. The RMC then directed the transcripts to be prepared at public expense in an order issued June 17th, 2024. And it has come to my attention that, 2 days ago? And this is October 16th. So October 15th, October 14th, those transcripts were officially transferred over to the next court. And we have them. Meanwhile, this court issued an order for a briefing scheduled in this appeal on April 22nd, 2024. That order set a 30-day deadline for appellant's opening brief, a 30-day deadline for the city's response, and a 15-day deadline for the appellant's reply. So that's 45 days. The court opened a briefing schedule, and in 45 days, they started doing this. Give me just a few moments here, folks. I'll be right back. Okay, folks, I got to keep it quiet, and I might have to wrap it up here shortly. So 45 days, yeah, that it took. So 60 days, out of that 60 days, 45 days was held up in court. The order did not make mention of the separate requirement that the appellate perfect his appeal by requesting a hearing pursuant to NRS 189.065 and NRCRP 19.38. Now, I believe we read over that 189.065. Let me just, yeah, we read over that. So let me pull open that rules. These are Nevada Revised Court Procedures, I think is what we call them. So let me stop sharing that and pull open those rules. Nevada Rules of Criminal Practice, that's what it's called. Nevada Rules of Criminal Practice, so appeals. And he's referencing Rule 19, appeals. Number 3, perfection of appeal, and subsection A. So he's referencing this. It says, the following shall be filed with the court to perfect an appeal. Defendant appeals. The defendant appealing a final judgment must file, as required by NRS 189.065 that we read earlier, a request for hearing with the court within 60 days, and the format set forth in the request for hearing form established in these rules. The court clerk must have the matter set for hearing within 150 days. Briefs. 1. The defendant's opening brief must be filed within 45 days of filing notice of appeal. 2. The state's responding brief must be filed within 30 days of filing the opening brief. And 3. The defendant's reply brief must be filed within 5 days of filing the responding brief. A reply must be limited to answer all new matters set forth in the responding brief. So I thought I seen something in here where they were required, when I was reviewing this, where they were required to include the transcript, but apparently I was wrong. Maybe we'll come across it. I thought we had that's, I seen that somewhere, but that could have just been my ADD talking in my head. So let's go ahead and go back to that filing. Okay. Continuing on. Contentions of the briefing scheduled and an ongoing transcript issue. The parties stipulated to extend the deadline for appellant's opening brief from May 22nd to July 8th. Neither of the parties' stipulation nor the order implementing it made mention of the request for a hearing requirement. The parties' discussion over the stipulation, the city did not raise the requirement. So basically, he says, Mr. Edgerton said, we need time to get this information. We need to gather all the documents. The lower court wasn't ready yet. And we didn't, the lower court wanted to play games with Ms. Schumann. And rather than doing it ex parte, it drug it out. So because they drug it out, it also drug out this 60-day rule, is what he's saying. And because the state did not pick it up, that, did not say, hey, oh, by the way, you still have 60 days to get us to perfect your appeal. Because they didn't raise it, they're trying, let's continue. He puts it out better than I can. Legal argument. This number 2 legal argument. The city's motion is based entirely on appellant's failure to request a hearing in this appeal by June 9th. It does not purport to advance any substantively important objective or principle beyond strict mechanical adherence to the requirements for perfecting an appeal. It is a petulant exercise that favors ambush over comedy. Elevates a tactical advantage taking over legal merit, and accentuates the city's animus towards appellant for daring to stand up for his rights to pursue his First Amendment activities. Oh my gosh. So well put, Mr. Edgerton. I love how you put that. Especially tactical advantage in a petulant exercise that favors ambush. She's trying to, she knows she doesn't have a case to stand on, so guess what? She's going to use every technical advantage to try to get this struck down and thrown out of court, just so that way she can make the case stick and the officer still gets his qualified immunity and the city don't have to pay out when this eventually turns into a civil rights matter. While appellant wonders what the purpose of NRS 189065 serves other than stumbling block or a trap for the unwary, the legislature has seen fit to maintain it as part of the statutory scheme for nearly 60 years. So this has been a rule for nearly 60 years, and she's trying to turn it into a technical bulletin, a technical rule. Whatever wisdom behind it, NRS 189065 is a mechanism by which an appeal can be dismissed for failure to prosecute, which ensures that this court's caseload is not clogged with unserious appeals. So basically, that is a mechanism for somebody just going, oh, I want to file an appeal, and never doing anything about it. You know, just to appeal for appeal's sake. Just because they can. Oh, well, it's not real because I appealed it. And then, oh, I'm not going to fight it either. That's what that's for. Okay. Whatever the wisdom behind it, NRS 189065 is a mechanism by which an appeal can be dismissed for failure to prosecute, which ensures that this court's caseload is not clogged with unserious appeals or abused as a mechanism for staying otherwise valid judgments. But no sincere reading of the record before the Reno Municipal Court nor before this court can conclude that the appellant is failing to prosecute this appeal. To the contrary, he has gone to extraordinary lengths to preserve his right to seek a judicial review of a conviction entered against him. If appellant has failed to meet his obligations under NRS 189065, it is due to his inadvertence rather than any lack of appetite to see this appeal through to a decision on the merits. Thus, the court should deny the city's motion, should be denied if it has any latitude to do so. The city hopes that the court will conclude that its hands are tied because NRS 189065 sets a time and manner requirement that requires strict compliance. For this reason, the city notes that ignorance of the requirement would be no defense, hoping to sidestep any discussion of whether fairness or professional courtesy would have obliged the city to warn its opponent that NRS 189065 deadline was nearing instead of lying in wait for it to pass. Similarly, the city waves away any legal effect that its own stipulation to extend the briefing schedule might have had a vis-a-vis the NRS 189065 deadline, whether on tolling principles or on the grounds of unfair surprise. So basically what he's saying is, you guys brought this out of left field. You never warned us. You never reached out to us. You never said, hey, by the way, you got about 30 days. You know, nothing happened. This was a gotcha in hopes that the court will go, well, no, you guys had 60 days. You failed. Case dismissed. It was a gotcha motion. In the summary, the city asked the court to look upon an obvious example of gamesmanship and subterfuge and concluded that the rules, mandatory as they are, cannot bend to avoid injustice. Fortunately, this court has ample latitude to engage in such bending on several grounds. So he's saying, oh, it's not as strict as she's making it out to be, Judge. Listen to what you can do. First, the case the city cites is for its quote strict compliance proposition favors appellant's position. The city misquotes again. The city misquotes. Second time they misquoted. First was on the reason why not every person needs transcripts just because they're just because they're indigenous, which is true, but because they're appealing, they have to get the transcripts. She misquotes it again. This is family law. This ain't criminal law. Go take these tactics to family law, Ms. Schumann. Anywho, the city misquotes Markowitz v. Saxon special servicing by excising generally. They left out generally from the beginning of the quotation. Perhaps because the Markowitz courts ultimately concluded that the language of the relevant rule favored strict compliance, but the policy and equity principles did not, and the latter outweighed the former. So they said policy and equity principles did not outweigh strict compliance. So whatever's favorable to the appellate is held in higher standard than the strict rule of that law. Okay. Where was I at? The policy. To determine if the rule's provisions require strict substantial compliance, this court looks to the rule's language, and we also consider policy and equity principles. These principles favoring appellant's appeal for a resolution on merits, and this court should do so unless it concludes that it cannot. He goes on to say, Markowitz is one of the numerous Nevada cases parsing the meaning of shall, which is generally regarded as mandatory language. Indeed, the legislature has carefully delineated between precautionary language like may and mandatory language like shall. Standing between these two extremes is must, which establishes a requirement without prohibiting the court exercising discretion to finesse that requirement. Although appellant has not reviewed the legislative history of change, he contends that it is precisely this distinction between must and shall that the legislature likely had in mind when it revised NRS 189-065. The statute has only been revised once since its inception in 1965, and it was to replace the words shall with must and trial with hearing. There would have been no reason to make this change if there were not daylight between shall and must. An appellant contends that the daylight in question is precisely the difference between concrete requirement that an ordinary ought to be satisfied and unyielding mechanical command that cannot be deviated from or varied from. And a lot of things saying, between shall and must, can and can't, this and that. Basically, he's saying that the court does have room in this and doesn't have to strictly comply. Finally, NRS 189-065 is operationalized by Nevada. What was that again? Nevada. Forget that. Okay. Operation by NRCRP 119.3A as part of Nevada Rules of Criminal Practice. Nevada Rules of Criminal Practice, that's what that means. This court has inherent authority to construe them so that they can provide for the just and fair administration of criminal actions. Where strict adherence to the rule would work an unjust or unfair outcome, this court has discretion to apply, construe, or even suspend that rule to achieve justice. So again, the court has the ability, if they find that the rule or law is unconstitutional, they can suspend it. Constitution trumps all. Order of priority. Constitution, federal law, state law, local law, or county law, local law. Order of priority, and that's what police seem to forget. And it should do so here with regards to the Nevada Rules of Criminal Procedure Practice 19.3A and NRS 189-065. The right to an appeal is a substantial right which should not be taken away unless clearly intended by statute. Any doubt about the construction of statutes regulating the right of an appeal should be resolved in favor of allowing an appeal. The city asked this court to snuff out an appellate's appeal on a technicality, even though appellant has consistently shown a dogged desire to have his conviction reviewed on its merits. This court should protect that substantial right and deny the city's motion. And it should. Conclusion: for the foregoing reasons, this court should deny the city's motion to dismiss the appellant's appeal on the most technical of grounds. Appellant has shown himself to be determined and serious appellant and not one deserving of dismissal for failure to prosecute the city's motion, and every indication of being little more than a sneaky trick deployed in desperation to avoid the decisions of the merit. And I agree with it. The city's motion has every indication of being more than a sneaky trick deployed in desperation to avoid the decision on the merits. And I would also add, to avoid criminal prosecution of a police officer and violation of civil rights, and to be held accountable for the violation of civil rights. Also, in principles of fairness, equity, and the value of improving the law through the iterative process of judicial review, all points in favor of having appellant's case resolved on the merits rather than a hyper-technical default. And then again, more court policy and boilerplate. Now, the court did rule on this. They did rule on this. And it's just a little bit down, and we're going to be done for the night. So I want to get through this, power through it. We got about 10, 15 minutes left, folks. So I'm going to keep this right at about 2 hours. And thank you for watching. Please hit like, share, and subscribe so that way when more content comes out, I can provide it. And I do apologize. I've been a little lacking on the content recently. So here is the court coming back. Again, Mr. England, Chief England, and the City of Reno. Order denying motion to dismiss. On April 19th, the Reno Municipal Court appeal proceedings hereinafter appeal. On June 24th, the City of Reno, hereinafter the city, and through Leann Schumann, Deputy Attorney, filed a motion to dismiss appeal for failure to request a hearing within 16 days, hereinafter MTD. Motion to dismiss. On June 27th, Mr. England, Chief England, hereinafter England, filed an appellate opposition motion to dismiss, hereinafter opposition to motion to dismiss. Also on June 27th, Chief England filed a request for hearing. On July 3rd, the city filed a reply in support of motion to dismiss appeal for failure to request a hearing within 60 days, hereinafter reply. The city highlights on April 1st, the Reno Municipal Court convicted Chief England of NRS 199-280, resisting a public officer, aka contempt of cop. Motion to dismiss at 1. The city further highlights that on April 9th, Chief England filed his appeal. The city ultimately argues that England failed to perfect his appeal by requesting a hearing within 60 days of filing the appeal pursuant to NRS 189-065, ID at 2. In opposition, England argues that the principles of fairness, equity, and value, improving the law through iterative process of judicial review and all points in favoring his case, resolve the merits rather than a hyper-technically default opposition motion to dismiss at 6. In reply, the city points to Plankinton versus 5th Judicial Court and argues that the court must dismiss the repeal reply at 1 and 2. It says here NRS 189-065 states the following: an appeal must be dismissed by the district court unless perfected by an application for the defendant within 60 days after the appeal is filed, the justice court having set for hearing. So basically, they're just going through and going, okay, here's your point, here's their point. And now here we get to acknowledgments. The court acknowledges that NRS 189-065 requires that the request for a hearing be filed within 60 days of appeal. being filed. However, the instant matter, the court entered an order for briefing schedule wherein the court made clear that after the conclusion of the briefing, a request for submission is to be filed. Moreover, the court notes that it entered a second amended order for briefing schedule on July 9th, wherein the court allowed Chief England until August 22nd to file his opening brief after the city stipulated to the extension. So Chief England's side, Mr. Edgerton, put in documents saying that we needed to extend it, and the city stipulated to the extension, or it stipulated to it, but it's, anyways. By stipulating to an extension of time for the briefing schedule, the court finds that the city has waived their argument that the appeal should be dismissed, has agreed to provide England more time to file his opening brief. So basically they said, by you going to court and arguing that he didn't need this transcript and dragging it out another month, a whole another 30 days, that you waived your right to it. I mean, she could have said, no, we're not going to, give him the transcripts and be done with it. And then it would have taken a few days or a week or two. But no, she had to play games and wanted to get in the way every single time. Okay, so going back here, the court finds that the city has waived their argument that the appeal should be dismissed as they agreed to provide England with more time to file his opening brief, implicitly acknowledging that England has the right to proceed with an appeal. Further, the city has implicitly acknowledged that under the rules of practice for the Second Judicial Court and the order for briefing schedule, the matter will not be heard until the notice of submission is filed after the city has responded to the opening brief. Also, as elucidated above, I guess that's how you pronounce it, the court has elected to enter a briefing schedule in the instant matter. Upon submission to the court will consider the matter heard and make its determination on the appeal. The court notes that within its inherent power to, quote, to control the disposition of cases on its docket with the economy of time and effort for itself, for counsel, and for litigants, unquote, Mayhew versus 8th Judicial Court of Nevada. Importantly, the Nevada rules of criminal practice are intended to provide the just and fair administration of criminal action, using its inherent power to control the disposition of the causes on its docket. The court does not find it appropriate to dismiss this matter and finds that rendering a decision on the merits of this case will allow for the just and fair administration of it. Based upon the foregoing and good cause appearing, it is hereby ordered that the City of Reno's motion to dismiss appeal for failure to request a hearing within 60 days is denied as of September 9th. And then standard court. So what does that mean, folks? Well, it means that the city don't know what it's doing. Plain and simple, folks. They're trying every technical aspect. They're trying to play family court and criminal court, in my opinion. They're trying to rely on technicalities. They're trying to subvert justice in favor of technicalities of the law rather than the fairness of the law. And again, this goes back to Ms. Schumann's job. She asked me if I had any legal training in First Amendment auditing, if I had any training in First Amendment auditing, if I had any legal knowledge. I'm going to put it to you this way, folks. You don't have to go to college to pass the bar. There have been people who've passed the bar on self-study. There have been people who just walked. I think I've read one point where one person just walked right in based upon general knowledge that they picked up, walked right in and passed the bar on their first try. There are some people who have failed the bar 10 times over, and then on the 11th try, they passed the bar, and they're shitty lawyers. I don't know about Ms. Schumann. I haven't researched any of her information. I'm afraid to, almost, because, her question if I liked Tony the Tyrant, but filing these petty motions to prevent somebody from getting transcripts just because you don't like the way that a person runs his life over their indigent status is not protecting one's constitutional rights that you signed off for when you took the job. Prosecuting somebody maliciously by trying to take away their appeal based on a technicality that you caused is not the right way to do things either. So, folks, let me pull this up here again. And we've shown this on live stream before, but here is Miss Schumann's AVO, you want to call it. She's licensed for 12 years. She's a 2012 is when she, and she's a child custody attorney in Yerington. University of Wyoming College of Law. Interesting, Ms. Schumann. Did they teach you Nevada law in Wyoming College? Oh, yeah. Mineral County District Attorney's Office. Deputy District Attorney. Maybe I should pull up your cases out of Mineral County. Anyways, I'm going to stop sharing that. And one other thing I want to do is point you folks to the city attorney's office. So if you folks have any questions, comments, or concerns for the city, remember, it is your First Amendment right to address your grievances with your government. So we only ask that you please do so respectfully and lawfully. We do not condone any threats or force or violence or acts thereof. And so if you want to hold the city attorneys accountable, you can give them a call. Let me kind of bump up this text on this. So this is Mr. Carl Hall. And as you can see, in the criminal division, we got Miss Leann Schumann here. But if you want to contact them, you can contact them through their website, reno.gov/government/department/city-attorneys/contact-us. They're open from 8 to 5 Monday through Friday and at nights, folks. 8 to 5. Oh, yeah. Criminal division gets an hour for lunch. Why doesn't the civil division get an hour for lunch? Anyways, they're on the 3rd floor of 1 East 1st Street in Reno, Nevada, P.O. Box 1900. And here's the phone number if you wish to call them, folks. Let them know your displeasure on all of these frivolous filings that they're putting in if you'd like. But I do thank you guys for joining. Please take a moment to like, share, and subscribe to my channel. I'm also streaming on the ADHD Auditor. Again, shout out to all my neurodivergent and neurotypical followers out there. If you guys have a moment, please head on over to Sacramento Community Watch's channel. Don't forget to like, share, and subscribe to them. Take a look at our content live stream. Get caught up on all this. We do thank you for going through this with me. Again, this is all public record. I'm kind of giving a big shout out here to Megan Fox and that umbrella guy who kind of urged me to do this indirectly. They're kind of going over a case with Jeremy Hales over at What the Hales channel as well, where he's fighting his neighbors. And they're going over case documents in real time. So why not I? So as more case content falls in, I'll be doing more live streams. When I get that court audio back, we'll go over this again and we'll put the court audio in there. We'll kind of go a little bit faster next time. But I do thank you for joining us. Thank you for watching, and stay safe out there and know your rights and know the law, folks. Good night.